Court is now in session.
All right. Welcome to our second case on the docket this morning. Thank you, attorneys, for participating by Zoom, and those watching us virtually. We appreciate you watching the Supreme Court today. In a moment, we're going to start the second case. When we do so, each side will have 30 minutes to argue. If the appellant wishes to reserve any time for rebuttal, please do so at the beginning of your argument. Let me also ask if appellants have decided how to divide the time.
Yes, good morning, Your Honor. My name is Jordan Scott. I represent New Body Concepts, LLC. The appellants have agreed to allocate 5 minutes for Mr. Miles, who is here on behalf of Dr. Mandy at Middle Tennessee Surgical Services, and I would like to reserve 3 minutes for rebuttal.
All right, Mr. Hibbner, you may call the case.
Donna Cooper et al. Versus Dr. Mason Wesley Mandy et al.
All right, you may begin.
The Tennessee Healthcare Liability Act applies to cases, including this one, that meet the statutory definition of a healthcare liability action. According to the express terms of this definition, the act applies to, and I'll quote from the statute, any civil action alleging that a healthcare provider or providers have caused injury related to the provision of healthcare services to a person, regardless of the theory of liability on which the action is based. It's undisputed in this case that it is a civil action and that the defendants are healthcare providers. So the appeal turns on the straightforward question of whether the action alleges injuries related to the provision of healthcare services. And the complaint is rife with allegations of injuries related to the provision of healthcare services. In fact, the complaint specifically ties injuries in this case to a surgical procedure. For example, the complaint alleges that the surgery resulted in pain, disfigurement, infections, lost income, and a strain on the plaintiff's marriage. With these injuries tied to the provision of healthcare services in the complaint, there is no question that the case meets the controlling definition and that the Healthcare Liability Act governs the case. The analysis should stop there, but the Court of Appeals went further and in so doing departed from the plain language of the statute. One way that the Court of Appeals departed from the plain language of the statute was by adding an element of consent. According to the opinion below, as it pertains to battery specifically, the injury was not related to the provision of healthcare services because Ms. Cooper's consent to the surgical procedure had been vitiated. But considering consent to determine if the act applies is at odds with the plain language and context of the act, this court's precedent in Ellithorpe, and also the policies and historical development of the act. Looking first at the plain language, proper statutory construction is to read the statute as it is written, without adding exceptions and without adding qualifications. And looking at the plain language of the statute here, the statute does not limit its scope based on consent. So adding a consent requirement is adding an exception to the act. And that is a task that is more appropriately left to the General Assembly. And certainly the General Assembly is capable of adding exceptions and has even added exceptions in other parts of the Healthcare Liability Act. For instance, the exception based on fraudulent concealment in the context of the statute of repose. Now, beyond just the plain language, also the context of the act demonstrates how consent cannot be a prerequisite or a hurdle that has to be jumped over in order for the act to apply.
Counsel, this is Justice Kirby. Wasn't the injury in this case just the touching itself, and the other things that you've described flowed from that? But the basic injury, they're basically alleging that there was not consent for this doctor to touch her, medically or otherwise. So how is that a healthcare liability action?
So the injury that's been alleged certainly is a touching in a sense, but the touching was a medical procedure. And because that touching was a medical procedure, that touching has to be related to the provision of healthcare services, because without a medical service being provided, there is no touching in the case. And certainly the other injuries that flowed out of that are related to that surgery. And so the act would apply.
Wouldn't it be the same kind of battery if somebody said, I was told that you're a licensed cosmetologist and you performed some procedure, and you're not a licensed cosmetologist, so my consent to have you touch me was vitiated?
I think that would be a little bit different, Justice Kirby, because if the allegation is that the person was not actually a licensed healthcare provider, then it would fall outside of the act for a different reason, which is an element that has not been placed in dispute in this case, because the injury has to be caused by a healthcare provider. And in that case, in your
Well, what if the doctor, Dr. Mandy was in fact a nurse, so a healthcare provider, but not a surgeon, not a physician? Would your answer be different?
My answer would be the same. If a medical service is being provided by a healthcare provider, regardless of what the official title of that healthcare provider is, if a healthcare service is being provided by a healthcare provider, looking at the plain language of the act would apply.
Mr. Scott, this is Justice Page. Does it make any difference here that the argument is that this healthcare provider said that he was board certified when he was not? What if he was not even a physician? How are those two allegations different, or two considerations different?
Those two allegations are different because if the allegation had been that he wasn't a physician, this is very similar to the cosmetology example that I was talking about with Justice Kirby. If the allegation is that he wasn't a healthcare provider, then the case would fall outside the scope of the act because of a different element that was not met. In that case, it would not be a healthcare provider performing a service.
Well, what if this doctor had raped the patient? I mean, are you saying that would be a healthcare liability action because the perpetrator was a physician?
No, Your Honor, because a rape wouldn't be the provision of a healthcare service, which is unlike a surgery.
Rapes have been known to take place of patients who were sedated or who were otherwise made helpless in the course of a medical procedure. Are you saying that's a healthcare liability action?
No, Your Honor. I believe that would be too remote from a healthcare service because rape would be an intentional sexual act that wouldn't be taken for any kind of healthcare purpose. Whereas a surgical procedure is a healthcare procedure, undoubtedly. And looking to the context of the act, Section 118, when we talk about whether consent would be a proper prerequisite, as the Court of Appeals held, Section 118 of the statute refers to informed consent cases as cases that arise in the healthcare liability action context.
This is not an informed consent case, right? This doesn't have anything to do with the patient not having risks disclosed to them. This has to do with something unrelated to disclosure of risk, simply the credentials of the physician. This is just straight consent or not consent. Informed consent is a subset of the overall category of consent cases. This is not informed consent, right? I mean, just the Black's Law Dictionary definition of informed consent has to do with the disclosure of risk. That's not what we have here, right?
I think arguably it could be an informed consent case because the physician's credentials and experience could pertain in some way to the risk and benefits of the procedure, specifically the risk of the procedure of having someone who has lower credentials or less experience. And some courts have found that misrepresentations about physician credentials constitute an informed consent case. And I would refer the court to the Howard case out of New Jersey, which we cited in our brief. And some courts have even found, though, that misrepresentations about physician credentials are so far removed that they don't even support an informed consent claim. That being the Dutchery and the Ditto cases from Pennsylvania and Hawaii. I think best case scenario for the plaintiff, this is an informed consent case because it's certainly not a battery case. A battery case is one in which there is no consent to the procedure. According to the precedent, this court has held that it is a simple inquiry to determine if there is a battery. And the simple inquiry simply looks at whether there was consent to the procedure that was provided. And in this case, there was consent to the procedure that was provided. Specifically, she consented to a breast reduction procedure and she received a breast reduction procedure. Now, the Coopers argue that the consent was vitiated by a misrepresentation about Dr. Mandy's board certification and experience. But for a misrepresentation to vitiate the consent, the misrepresentation has to go to the essential nature of the invasion. That means that the misrepresentation has to be about how the plaintiff is being touched, what procedure is being performed. And we've cataloged in our brief the—
Wait a minute, you're saying that it's not basic to the patient's decision whether the person who would perform the procedure is appropriately certified for it? You're not really saying that, are you?
That's not quite what I'm saying, Your Honor.
Saying that's tangential, it really wouldn't figure into whether the
doesn't go
patient
to
would
the
actually
nature.
consent?
It doesn't go to the nature of the procedure itself. It doesn't go to the
No,
nature
it's
of
a
the
different type of
touching.
misrepresentation. That's true. But how can you say that would not vitiate consent?
It wouldn't vitiate consent because it doesn't go to the character, the essential character of the touching involved. And I would also point out too that the board certification is not required to conduct surgery in Tennessee. Any licensed doctor can perform surgery in this state. Board certification is a voluntary credential, and so it doesn't have a bearing necessarily on whether the physician.
Well, that might be pertinent if the lack of board certification had been disclosed to the patient, and then it could be explained. But that's not needed. But that's not what happened here, right?
What the allegation is that it was not disclosed that the doctor was not board certified. Now, whether the consent was vitiated or not, ultimately this court doesn't have to decide that because consent is not a prerequisite to applying the act according to the plain terms of the Healthcare Liability Act. And for that, I would also point the court to its own precedent in Ellithorpe. In Ellithorpe, the plaintiff alleged that a social worker counseled a child without parental consent in violation of a court order. But even with this lack of consent, this court still held that the act applied based on the plain language and broad scope. The court even cited the allegations of counseling without consent as an example of allegations of injuries that relate to the provision of healthcare services. So clearly, this court has not considered consent to be a prerequisite for the act to apply. And this court should follow the same analysis in Ellithorpe and look at the allegations in the complaint, and the allegations in this complaint do pertain to injuries related to the provision of healthcare services, specifically a surgery. Looking too at the policy and history of the act is intended to decrease litigation costs for healthcare providers to avoid what this court called a medical malpractice insurance crisis by enabling pre-suit investigation and resolution, and also about weeding out frivolous claims. And the General Assembly demonstrated a clear intent for the act to apply broadly in at least two ways. The court abrogated the nuanced approach of a state of French, and instead of a state of French, it now has enacted a new and broad statute that extends the application of the act beyond just medical malpractice. It applies now to claims meeting the definition regardless of the theory of liability on which the action is based. But considering consent to a physician-patient relationship restores some of those old limitations from when the former act was exclusively applied to medical negligence claims. And it would chip away at the policy goals of the act by allowing careful or creative plaintiffs to file suit without giving pre-suit notice, as long as they allege some element of a lack of consent. Now, the misrepresentation claim, the Court of Appeals treated the misrepresentation claim a little bit differently than the battery claim. The decision still depended on consent, but it also focused on the timing of the alleged misrepresentation. Specifically, the court found that the alleged misrepresentation occurred before Ms. Cooper consented to a physician-patient relationship. Accordingly, and based on that, the court held that the defendants were acting in a business capacity instead of a professional capacity for the intentional misrepresentation claim. There are a couple of problems with that holding. One, consent doesn't determine the application of the act, which I've already discussed. And two, the alleged misrepresentation occurred during an informed consent discussion, which is related to the provision of healthcare services. An informed consent
would it be different if this plaintiff had said, I looked at their marketing, I looked at their advertising, and I relied in part on that? How does that change the picture?
If it's just relying in part on that, then it would still be the same, because it would still be the same outcome here, because the complaint would still be alleging injuries that relate to the provision of healthcare services, even if there is some other allegation about relying on advertising in there as well.
If plaintiff said, I saw their advertising, and I saw their advertising about all their qualifications to do this kind of surgery, so that's why I went there. And they reinforced, and when I got there, they reinforced the same misrepresentations that was in their advertising. Does that change the picture? So it got her in the door.
If the injury is still the touching that's alleged in the complaint, because I think it would ultimately depend on what's being alleged in the complaint. And if the injury is still the touching in the surgical procedure, then the outcome would be the same, because the civil action would, now, if it is just a purely relied on the advertising, that may be a different question, but that's not what we have in this case, because although there's a reference to advertising, I believe in paragraph 4 of the complaint, there is no allegation of any reliance on any advertising. The reliance in this case was purely alleged to have been based on the in-person informed consent discussion. And that's from paragraph 10 of the complaint.
Mr. Scott, this is Justice Page. I'm having trouble after reading all these materials for preparation for today, determining where the business practices stop and conduct subject to the act began. Can you enlighten me on that?
I think the business practices certainly stop before the informed consent discussion, which is the discussion where the consent was provided and where the alleged misrepresentation that was alleged to have been relied upon occurred. Because that informed consent discussion, that's a conversation between the healthcare providers and the patients principally to discuss the risk and benefits of the procedure. It necessarily occurs before consent is provided. In the American Medical Association, the opinion specifically 2.1.1, which I cited in our reply brief, I believe, defines this informed consent process as a communication between a patient and physician that results in the patient's authorization or agreement to undergo a specific medical intervention. And
well, how does that work in the case of this was an elective cosmetic procedure, basically, and in that context, there can be a lot of selling that goes on in the physician's office. If I do this, you're going to look like this. So, I mean, I understand your argument in the situation where the patient needs something done to, health-wise, but for an elective cosmetic procedure, isn't it mushier?
I think there could be some business discussion within that conversation.
So how do we draw to Chief Justice Page's question? How do we articulate that? Because we have to think about this in a broader context.
Well, the consent discussion cannot be divorced from the professional components of that consent discussion. I don't think can be divorced from the conversation. So certainly by the time of the consent discussion, there are professional components of that. And so there would certainly be an application of the act to that. Now, whether it's, things that occurred prior to that, I think is a different question. But here, the conversation occurred during an informed consent discussion.
So you're saying that even if there's a consent discussion and the doctor has photos up about what she might look like, and you're going to look fabulous and that sort of thing, that's all medical. This is strictly healthcare. Once they enter the doctor's office.
Yes, Justice Kirby, and I would point you to the language of the act, which is, does the complaint allege an injury related to the provision of healthcare services? And it's still related to the provision of healthcare services at that point. This informed consent discussion, there are ethical and legal duties both within the context of that discussion. And the discussion, according to a previous Court of Appeals opinion, that discussion is part and parcel of the surgical experience. So injuries that result from that discussion are necessarily related to the provision of healthcare services. And the consent discussion can't simply be a purely business activity.
Mr. Scott, let me ask you this. This is Justice Lee. Assuming that the plaintiff establishes that the doctor did intentionally misrepresent credentials and that she did not, otherwise she would not have agreed to this, so there was a battery, what would her remedy be for that?
Her remedy for that, she could, if a battery claim is established, she could recover damages for the unlawful touching. I believe that also includes consequential damages, although I haven't researched that specifically for today, as I was focusing more on the application of the act.
I mean, we're taking what's in the complaint as true, and she says the credentials were misrepresented, and my consent is not valid. So what does that And that is a wrong. I mean, if that is established, she was wronged in that regard by the doctor, what would her damages be?
My understanding is, Your Honor, that her damages would be, she could receive nominal damages for the touching, but I believe she could also receive consequential damages that result from that touching, so any injuries that result from that touching.
Is that what she's claiming here, though, that she's saying, you touched me, I didn't consent, and my damages are this, botched surgery, essentially. Isn't that what she's claiming here?
That is what she's claiming, Your Honor. However, the question that the court has to decide today is simply whether the act applies to that allegation and to the civil action as a whole. And it does, because the allegations in the complaint meet the definition of the Healthcare Liability Act. So what she's ultimately able to recover if she had a damage is, I believe, a different question, because all that we have to decide here is whether the act applies and whether she should have complied with the pre-suit notice and certificate of good faith provisions in the act. Okay. And although I've talked about the Court of Appeals holding for battery and misrepresentation separately, I don't mean to endorse the practice of dividing an action into Healthcare Liability Act claims and non-Healthcare Liability Act claims. But
don't we in fact have that? We have part of it is an intentional misrepresentation where the plaintiff says, I paid for this surgery that I didn't consent for, right? I mean, that's part of the damages, what she paid.
That is part of the damages, Your Honor. I would contend that is still related to the provision of healthcare services because the alleged misrepresentation occurred within the context of that informed consent discussion. But practically,
you think even the financial damages, purely financial damages, are subject to the Healthcare Liability Act?
I think they are in this case, and they would be in any case that meets the definition of the Healthcare Liability Act, which refers to injuries related to the provision of healthcare services. And because that injury flowed from the informed consent discussion, it would be. But I would also like to point out that the statutory text and this court's precedent doesn't allow dividing a claim. Because the act applies broadly to, quote, any civil action that meets an operative definition within the statute, and action is broader than a claim. It's synonymous with a lawsuit. And I would refer the court to Garner's Dictionary on legal usage, specifically the entry on suit, lawsuit, action, case, and cause. And this court addressed something similar to that in Ellithorpe, in which Ellithorpe rejected a claim-by-claim approach. In that case, there were many claims involved, but the court simply looked at whether the complaint, generally speaking, alleged injuries related to the provision of healthcare services, and based on that, determined that the entire case should be dismissed for failure to comply with the Healthcare Liability Act. And Your Honors, I see that I've run out of time. If there are no other questions, I will conclude my argument.
Thank you. Mr. Miles, you may start.
Thank you, Your Honor. May it please the court, I'm Eric Miles. I represent Dr. Mason Mandy in Middle Tennessee Surgical Services. Try to address very briefly some of the questions you all have asked, Your Honors have asked today. An earlier question from Justice Page related to how the court distinguishes between an HCLA case and a case that is alleging effectively monetary damages stemming from a medical battery or some other action that falls outside the act. The Court of Appeals focused on the Franks decision and used the analysis of the court in Franks to arrive at a decision that a case for medical batteries such as this one or some of the other claims alleged here can fall outside the act, and in their decision did fall outside the act. However, I want to point out that the Franks decision makes a very clear distinction. Plaintiffs dealing with these types of actions against healthcare providers have two vehicles. They have the Tennessee Consumer Protection Act and they have the HCLA. If the plaintiff is pursuing a claim for monetary only damages stemming from business practices, advertising, improper billing, etc., they may do so under the Tennessee Consumer Protection Act. They cannot pursue a claim under the Tennessee Consumer Protection Act and the HCLA. They get to choose one or the other. That's what the Franks decision noted. The Tennessee Consumer Protection Act critically only applies to certain types of injuries: ascertainable loss of money or property, real, personal, or mixed, or any other article, commodity, or thing of value. Bodily injuries have not been recognized as recoverable under the Tennessee Consumer Protection Act. We can look to the complaint in this case to see the types of injuries the plaintiff is seeking. The plaintiff is seeking bodily injuries. Their entire complaint and damages sought pertain to bodily injuries. The monetary damages alleged relate to pecuniary damages that flow from the alleged bodily injuries. The
Plaintiff
plaintiff
also in the complaint says, I paid, I don't know, $4,000 for this surgery I didn't consent to.
I don't believe they allege that in the complaint, Your Honor.
Oh dear, okay.
I'll have to look back at it, but I know they allege pecuniary damages. In any event,
Well, are you saying, all right, when I asked your co-counsel about an intentional misrepresentation claim where the plaintiff says, I didn't consent to this, my consent was vitiated, and I paid $20,000 for this surgery, I want my money back. He says that's subject to the Healthcare Liability Act. I mean, it sounds like you're saying that the plaintiff has to choose, but the Healthcare Liability Act doesn't let you choose. If it applies, then you are subject to its provisions. So do you disagree with your co-counsel? What's the nuance there?
no, I do not disagree with Mr. Scott. I believe he's exactly correct. In every healthcare liability action, plaintiffs contend that they're entitled to recovery of pecuniary damages, medical expenses, et cetera. That is almost universal. That does not take the claim outside of the HCLA. What the distinction is and what Franks addresses is when the claim is centered on a business practice separate and distinct from bodily harm, physical injury, a plaintiff can go outside the HCLA and pursue that action.
Okay, plaintiff says, I saw the ad, I saw the billboard that talked about their credentials. I was persuaded by that. I went in and I paid $20,000 for the surgery. I ought to get my money back. That's it.
That's all they
That is or is not governed by the Healthcare Liability Act.
You're saying that's all they asked for. They asked for their money back for the surgery because of deceptive advertising.
Right.
That's a TCPA claim.
Not a healthcare liability.
Not a healthcare.
Why is that not an action alleging that a healthcare provider has caused an injury related to failure to provide, or regardless of the theory of the action? Because
that is not an action cloaking claims for business practices or monetary injuries in hopes of traveling for a bodily injury. That's what the Byington court directly addressed, and this Supreme Court, Your Honors, declined the application, which was you cannot cloak, including a claim for medical battery in the Byington case, claims that fall under the act by arguing or claiming other types of common law torts, which is what the plaintiff has done here. That is why the case should be dismissed.
Okay. Thank you, Mr. Miles.
Thank you.
Preston?
We can't hear you, Mr.
Hear-
There you go.
There you go.
Can you hear me now?
Yes, sir.
Okay, thank you very much. Good morning, Your Honors. I would like to address one thing that was just raised, and that was in the plaintiff's complaint at paragraph 11. We do specifically state that Ms. Cooper paid $4,000 to the defendants in this matter for this procedure, and that raises another issue I'd like to address, and that is, in this case, first of all, I would say both Judge Martin and the Court of Appeals got this case right and were correct in their rulings. But the timing of this case is very important, because Ms. Cooper met with Dr. Mandy and Rochelle Norris, who was a nurse or some type of employee of New Body on September 19th of 2014. And it was at that meeting that the representations about Dr. Mandy's board certification were made to her. And based on that, she agreed and paid the money, $4,000. And her procedure was conducted on October the 2nd of 2014. So roughly 2 weeks later. I respectfully submit that that's important in analyzing this case because at that point when she agreed, she was not a patient of Dr. Mandy. In fact, essentially, Dr. Mandy put on his business hat rather than his professional hat at the time, and maybe it was mixed to some degree, but he was a salesman on September 19th when she entered into that contract. And those representations were, and we have to take the complaint as true for purposes of the procedural stature of the case at this point, but that's what she relied on. This is a board certified physician.
Well, now, how is that? This is Justice Kirby. How is that true, Mr. Preston? I mean, this wasn't the office business manager talking to her, the marketing guy. This was the physician talking to her about a medical procedure. He may have been selling, but he was also describing what would happen and talking to her about what the risks were involved. It's part of the consent, the informed consent process, right?
It can be, but, and it obviously is with an informed consent case, but the allegations are that both Ms. Norris and the physician were at the meeting on September 19th. It was a sales job. It was like buying a timeshare. Essentially, this is a for-profit entity and a doctor that works there who sold her on a procedure that was, as Your Honor pointed out earlier, and I think this is important, was an elective operation. This is different than had she arrived at a facility.
So are we going to apply a different standard to elective procedures? I mean, I don't understand. Part of my question to your opposing counsel was, are we in a position where we have to suss that out? I mean, do we have to see deposition testimony about whether the doctor talked to her about the medical aspects of it? And it's so intertwined with the selling here. I don't know how we could unscramble that egg.
Well, I would submit that it's unnecessary to do so because the crux of our position, and I think where the wrong here was in the selling of the service and based on false statements. And that alone, I respectfully submit, changes the nature of what kind of case this is.
Mr. Preston, this is Justice Page. In reviewing this, I looked at your complaint, which we take as true, and you talk about the misrepresentations of the board certification experience. And then in paragraph 10, you say, those false representations, quote, form the basis of her consent, end quote. Doesn't that make this an informed consent case?
No, Your Honor. I think within the context of entering into the agreement for the provision of the healthcare services, that is what is vitiated by that fraud. And so it is meshed, frankly, because there were both conversations that happened at that meeting based on our complaint. But what is tantamount, and at this point, before Your Honors, is a plaintiff who says, what I relied on was this man's certification. And had it not been for his certification, I would have not entered into the contract. And that contract was for the—
Preston, this is Justice Bivens. So are you telling us that the courts are going to have to delineate between and among different conversations in the same meeting to determine whether the Healthcare Liability Act applies or not?
No, Your Honor. I think, or I would respectfully submit that I don't think it's necessary to delineate. I think and submit in this situation, you have a person who is seeking healthcare services and is actually negotiating about these services. The $4,000 was paid. That was part of the price. and it was based on what she learned from this physician, Dr. Mandy, and Rochelle Norris, the representative of New Body. And so that was a sales
in that same conversation, though, were there not discussions about the risks involved in essentially the informed consent process?
That is not meted out in the, I believe it's true that everything about the process was probably discussed at that meeting. I'm not going to.
So then, isn't it, so then back to my basic question then, so we would have to parse out whether the claim relate, see what the Healthcare Liability Act applies to. It applies to part of it, but not all of it.
No, Your Honor, because I think the basic concept of fraud and contracts and the vitiation of contracts based on fraud answers that question for us. And had she not, and this is clear and undisputed, had she not relied upon the false representations of Dr. Mandy and Rochelle Norris of New Body Concepts, then she would have never entered into this agreement for this elective procedure, and therefore none of the following actions would have occurred.
But
And so
counsel, if you look, this is Justice Kirby, if you just look at the language of 2926-101A1, it's extremely broad, as Eliathorpe said. Any civil action alleging that a healthcare provider caused an injury related to the provision of healthcare services. I mean, how does this not fit under that umbrella?
Because the tort about which we complain occurred prior to the provision. The tort occurred in.
How is it not related to the provision of healthcare services?
Well, it's related to the transaction, just like in some of these other cases where you have a physician trying to upsell or sell a device or something, that the physician, once the physician puts on the business hat as opposed to the professional hat, that's a distinction. In this case, that's what we have as pled. And so related to, if there weren't an issue about the misrepresentation, there is no question that this would be a case that fell under the Healthcare Liability Act. But it's important that, in my view, and I think the case law supports it, the distinction, respectfully, is not that difficult to make between the event in which Dr. Mandy misrepresented his qualifications in order to entice my client to sign the contract and pay them money. That was a different scenario than had she already been in his care. He was already her physician, and he said, well, let's do this procedure, do that procedure.
So how are you, I mean, at the end of the day, what we are asked to do is interpret a statute. And that statute would be 2926-101A1. So what language are you focused on that supports your position? I want you to point me to the language, because that's what we are doing.
Well, the related to, I think that the related to language, when you see the facts of what happened here as we set forth in our complaint, paragraphs 10, 9, 10, 11, that is not related to the provision of healthcare services. If the statute, and the legislature could have done this, if the statute intended for any action to be subject to the statute, they
would have written it broadly and said something like related to healthcare. I mean, it's very broad. I don't know. I'm trying to figure out some authority that you have for interpreting this as not related to the provision of healthcare services.
Well, I think if you look at the recent cases where there's been a delineation, the Franks versus Sykes case, and then we have a couple of federal cases that are following in the same line where the difference between the business services and the professional services are distinguished.
But the Franks case still dealt with billing practices, and the billing practices that occurred well after the services were provided. Totally separate issue.
Well, it is separate, except for this is a billing practice too, Your Honor, respectfully. It's billing. I'm selling you on a service. I want my money now. You pay me now in advance, and then I'll give you the service. That is really, respectfully, not that distinguishable from, okay, we're providing the service on credit, we'll bill you later, or an issue with billing. I think those are business practices that can be meted out and easily distinguished.
Mr. Preston, let me ask you this. If this surgery had gone well, and afterward, your client said, well, you misrepresented your qualifications, and there was an intentional misrepresentation, what would she have been entitled to anything, or would she have had a cause of action? If the surgery had gone well?
That's an interesting question. I think, and that when you analyze the case, her complaints arose after problems arose, which so often happens in consumer issues.
But if that tort occurred, see, guess what? This is what I'm getting at. If the tort occurred right then when he was upselling her or pressuring her to pay this money, have this surgery done, agree to this surgery, if that's when the tort occurred, as I understand what you're saying,
yes,
at that point, she had no damages. The damages occurred when he botched the surgery and caused her harm. So it seems to me the underlying gravamen of the complaint here is that the doctor did not deviated from the standard of care and caused an injury. Had that not occurred, she would not be in court. But it did occur, and it's hard to get around that is what underlies this entire cause of action.
Well, her consent was vitiated by the fraud. And so just the touching was a claim, number one. So we have the battery claim, but then also, just like in a consumer transaction, if someone misrepresents to you the condition of a vehicle, you buy the vehicle, and then you find out, well, he was wrong about a certain aspect of it, but the car is what he said it was. It's good. He lied, but it's okay. I mean, because I'm not harmed. And
So
in
it
this
goes
case,
more to the amount of the damages rather than the essence of the injury is what you're saying. Like a trespass, if somebody doesn't have consent to come on your property and they just step on it, you're not damaged very much. But if they trash it, that goes to the amount of the damages.
well, that's what yes, Your Honor, to a degree, but I would submit that in this instance, the harm was learned after she started inquiring as to, could a physician, or really a true physician, have done this? What happened? She learned later, this guy's he's not board certified, even though he said he was. Well, that was an important aspect to her as to whether, what his qualifications are. She didn't realize and didn't learn that the misrepresentation, A, had occurred, and B, that it was a material misrepresentation because she suffered the consequences. And so even though perhaps we can't recover for certain types and categories of damages as a result of this misrepresentation, although I disagree with the restatement on that for the record, in this case, the misrepresentation through that revelation did result in damages, and even though they may not be physical that she can recover for, they are pecuniary. I mean, she should be able to recover. Hey, I paid $4,000. I've lost so much time from work because of these misrepresentations and the result thereof. And so even though there are some that are physical damages that perhaps are not recoverable, there are financial damages as a result of the misrepresentation, just as if she had bought a car from somebody who had misrepresented whether it had been wrecked before, or was it a flooded vehicle or whatever else. So
Don't you have to bring in, Mr. Preston, if you get by this motion, aren't you have to bring in expert testimony to say, yes, he misrepresented, and two, these damages she has were caused by this misrepresentation. In other words, you're going to have expert testimony, aren't you, to link your damages to the tort or to the misrepresentation or the deviation from standard of care in terms of representations? And that sounds a whole lot like a healthcare liability case.
Your Honor, respectfully, I do not believe that we would be required to have expert testimony. I think that the case law would allow her to testify as to her own personal experiences and observations here, and the pain, what she paid him, that the she could testify on her own knowledge as to the effect after she had the surgery, her inquiry thereafter, how much time she lost from work. These are things that respectfully, I don't think require expert testimony. And also as far as the battery goes as well, I respectfully submit, I don't think that we would have to, because it's our position, the Healthcare Liability Act does not cover this case.
Well, Mr. Preston, let me ask you this then. If this court were to determine that in fact this case does fall under the Healthcare Liability Act, there is no argument that your client did not provide the pre-suit notice or the certificate of good faith that's required for a Healthcare Liability Act. Is that correct?
Your Honor, we did not comply completely with the Healthcare Liability Act on pre-suit issues. That is true. And that's not in dispute. And our position on that is that we were not required to, because we fall outside of the act.
Mr. President, you're not penalized if you don't use all your time. We're through with questions.
Okay. Thank you, Your Honor, and Your Honors. I think I've address the issues that Your Honors were interested in, and I'll rest at this time.
Thank you, sir.
Thank you, Your Honors.
Your Honor, just a couple of brief points on rebuttal. First, a factual clarification. The complaint does reference a $4,000 payment, but the complaint doesn't ask specifically for any reimbursement of that $4,000. When the complaint discusses damages and injuries, it's talking about damages that are flowing from the alleged botched surgery. Also, we have everything that we need to decide the case on the face of the complaint here. The complaint specifically alleges injuries that are related to the provision of healthcare services, specifically in paragraph 14 through 16 and others, but those provide a good example. If we have to get into depositions, the intent of the act is undermined because at that point you could have a case that goes forward and litigation costs are incurred, even though there was no pre-suit notice, just to decide if pre-suit notice was ultimately required to begin with. But in this case specifically, we already have allegations on the face of the complaint that refer to injuries and specifically injuries that are explicitly tied to the provision of a surgery. And so I would respectfully submit that we have everything that we need on the face of the complaint here.
So let me make sure I understand, Mr. Scott. You're saying we don't need to remand the case?
I'm saying that we don't need to, you wouldn't need to remand the case for deposition. There were a few questions during Mr. Preston's argument about whether depositions would be needed to parse out whether the act applies to this case. And I don't believe it does. And for a couple of reasons. One is the face of the complaint shows that the injuries are tied to the provision of healthcare services here, but also because the statute refers to the allegations. When we look at the definition of what a Healthcare Liability Act is, it is a case that alleges injuries related to the provision of healthcare services. So baked right into the statute depends on the allegations in the complaint. And I think the purposes of the statute would be undermined if a case were allowed to proceed without pre-suit notice through the deposition phase, because that would run up litigation costs for medical providers. And the whole idea of a pre-suit notice is to prevent prevent medical providers from incurring those kinds of medical costs.
But we weren't asked to rule on whether the motion to dismiss should have been granted. We were just asked to rule on whether it's subject to the Healthcare Liability Act. So we would have to remand it, right?
Correct.
Okay.
Okay.
Just that remand wouldn't necessarily involve a direction for depositions and other discovery. I would also like to point out that the act can apply to part of the case and not to, can apply to part but not all of the case. The language, as I discussed in my principal argument, is any civil action, and a civil action is broader than a claim. And in this case, because the complaint does include those allegations of injury related to a surgery, a straightforward reading of the statute shows that the act applies to the civil action as a whole. Thank you, Your Honors.
All right. Thank you, counsel, for your good arguments this morning. And those of you who are watching us on live stream, that concludes the October 2021 docket. Mr. Hibbert, you may adjourn court.
This Honorable Supreme Court of Tennessee is now adjourned.